Hi, today I'm going to share with you an overruling decision of the Honorable Supreme Court in MSR Leathers versus Palaniappan case pertaining to check bounce that was rendered in 2012. This decision was rendered by the three-judge bench based on the reference from a two-judge bench. I'm making this video because one of my subscribers in the name of Lightspeed75 made a comment that my earlier video bearing number 212, which is a Sadanandan's case. Briefly, Sadanandan's case speaks about a check bounce. Notice was sent within 30 days and accused sought time. Therefore, complainant gave time again and bounced the check again, and second notice was given. And this all happened within 6 months, because before 2012, this case was pertaining to 2012. Before 2012, the time and the validity for the check is 6 months. After 2012, it is 3 months. So all this happened. Sadanandan gave a lot of time to the accused. The complainant gave a lot of time to the accused because it was 6 months available for him. Now it is 3 months. So based on the second notice, Sadanandan filed a check bounce case, which was found fault with by the Honorable Supreme Court. It reached Supreme Court, and Supreme Court found fault with the case filed on the second notice based on the second time bouncing of the check. In that Sadanandan's case, Supreme Court held that once a check is bounced, right is accrued to the complainant, and once notice is sent and the amount is not repaid in 15 days, cause of action accrues. So once a cause of action is accrued based on the first time bouncing of the check, there cannot be second cause of action. That is what Supreme Court created the principle in Sadanandan's case. So the complainant has to can bounce the check any number of times, but he has to send the notice only once, and once the notice is sent and once the notice is not honored within 15 days by payment of money to the complainant by the accused, cause of action will arise, and within 30 days the complainant has to file a case in the check bounce court. This is the sum and substance of Sadanandan's judgment. Now Sadanandan's judgment was prior to 2002 amendment. 2002 amendment was pertaining to the condonation delay. If at all you could not file a case in 30 days, court can condone the delay only after 2002. Now in MSR Leather's case, it is post 2002 amendment, and Sadanandan's case is pre 2002 amendment. In MSR Leather's case, Supreme Court overruled the Sadanandan's decision only to the limited extent of permitting check bounce complaint to be filed based on the second notice also. That is the only difference between MSR Leather's case and Sadanandan's case. Nowhere Supreme Court found fault with Sadanandan's case. In fact, it has reiterated in paragraph 6, paragraph 16, paragraph 17 supporting the Sadanandan's case. In fact, Sadanandan's case is very clear about the right that is accrued to the complainant once a check is bounced, about the cause of action that is accrued to the complainant once the legal notice is sent and which is received by the accused and the amount is not paid by the accused within 15 days. There is absolutely, Supreme Court did not find fault with the Sadanandan's case. In fact, Sadanandan's case was in force for 15 years. Supreme Court rendered a lot of decisions based on Sadanandan's case. It was very much clearly enunciated in the overruling decision in MSR Leather's case in para 16 very clearly. Lot of decisions of the Honorable Supreme Court pertaining to check bounce cases also, and lot of decisions all over India. It was a law for 15 years. So many high courts gave decisions, many trial courts gave decisions based on Sadanandan's case. And even now, because it is overruled, Sadanandan's case doesn't go into dustbin, because many decisions which are still in force are based on Sadanandan's case. Supreme Court clarified that MSR Leather's case is only an extension of the interpretation of Sadanandan's case, only the addition of the principle. In summary, MSR Leather's case is based on promoting the settlement between the complainant and the accused. In fact, Sadanandan's case is against the complainant. MSR Leather's case is for the complainant, because after rendering the decision in Sadanandan's case, there were increasing check bounce cases because The opportunity was very much limited to the complainant to file a case once the legal notice is sent. That aspect was relaxed in MSR's Leather. So MSR's Leather's case is equally good. Sadanandan's case is also equally good. But it is better for the complainant to file a check bounce case immediately after the first notice is sent, in order not to have any sort of confusion. Though he can bounce the check a number of times within 3 months, he can send notice a number of times, but sending notice more than once appears to be generally uncommon. As per my understanding, sending first time notice and second time notice, third time notice is treated uncommon by the clients also. Therefore, notice can be sent, but as per MSR Leather's case, notice can be sent anytime, a number of times, and the last notice will come into force, and that too within 3 months. This is important. So it is a relaxation promoting settlement. And after the last notice, last bounce will happen only within the end of 3 months, within 90 days. And after 90 days, the complainant has to send a notice, and that notice must be honored by payment of money within 15 days, or else the complainant has to approach the court for filing a check bounce case. So it is to relax. The relaxation for settlement is what I understand. But nowhere Supreme Court found fault with the Sadanandan's case. In fact, MSR's Leather's case is an otherwise form of interpretation, because 138 and 142 did not speak of sending the notice for the second time or third time. Notice can be sent. This is the interpretation that was taken. Supreme Court speaks in many languages. So therefore, it may have overruled the Sadanandan's case, but in principle, there are a lot of principles that are culled out in Sadanandan's case. In MSR Leather's case, the cause of action, the expression of cause of action in section 142 and the expression of commission of offence and launching of a criminal complaint by the prosecution in a criminal case. Unlike in a civil case, the expression cause of action, this was explained in MSR's Leather's case. In Sadanandan's case, the principle about cause of action, the principle about accruing right was discussed. Right now, MSR Leather's case is in force as per Article 141 of the Constitution of India. It is a law that is in force in India. Whatever the law that is declared by the Supreme Court through Article 141, it will be in force in India till it is overruled. So with great respect, para 6, para 16, para 17, para 24, Supreme Court supported Sadanandan's case. In fact, in para 16, a lot of Supreme Court judgments were also given. You kindly go through the judgment if you are interested. Therefore, MSR's Leather's case gives relaxation to the complainant to send a notice again and again and file a complaint based on the last notice. Thank you. Thanks for watching. Bye-bye.